All right. We are live and recording.
Thank you, Madam Clerk. Good morning and welcome to this morning's session of the Single Justice Session of the Massachusetts Appeals Court. Today is Wednesday, June 10th, 2020. My name is Catherine Hand. Counsel, would you introduce yourselves, please?
Attorney Brian Wasser for the appellant, Christopher Smith.
Good morning.
Attorney Franciscus Lepianca, Mackenzie and Sowen for appellee, Bank of New York Mellon as trustee.
Good morning.
Good morning.
So we're here today on Mr. Smith's motion for waiver of an entry fee. And I'll be happy to hear from each of you, 15 minutes per side. Madam Clerk will keep the time. You'll see a clock up on your screen. No rebuttal. And Mr. Wasser, whenever you are ready, feel free to begin.
Thank you, Your Honor. Your Honor, on the motion to waive the fee, you have, actually, I want to make sure that you do have all of the filings that we put in, but the most updated one, as you'll notice, is a bit of an anomaly because of the emergency COVID legislation that added, I think it was $600 extra a month to, or excuse me, $2,200 a month is what it looks like he got for unemployment. And as it indicates in his affidavit, that's going to expire July. And also, it would appear that when he put in his average monthly income, what he should have done that he looks like he didn't do is do a 12-month average. So you'd have to look at his prior indigency of affidavit, and I think that gets like a 9-month credit. And then when you do the math and give 3 months to his current, even if you were going to include the emergency unemployment, that ends up being about $7,000 a month. In any event, I mean, the math is pretty clear. You know, he's without the emergency income, he's looking at $100 in the positive on his total income. And so for that reason, he just simply, he's in an indigency status. And if we were to couple that, I don't know that we really do or if it's appropriate, but obviously if we were to couple that with the demand for, you know, an appeal bond, all the more reason why he would be statutorily deemed indigent under the subsection C.
Okay. Other than that, I'm sorry, go ahead.
Yeah, I guess I would just add that, you know, this is sort of an unprecedented issue, and I don't really, I mean, whether we would even calculate into this equation these kinds of emergency fundings, I don't know that that's really appropriate. I don't think that's, you know, what the purpose of that extra money was intended to be used for. And in any event, as I say, it's temporary, and I don't think it really should be added to the calculation. So I just wanted to add that piece. But.
And is there any authority that you have for me to indicate that it shouldn't be included other than the explanation that you've already provided?
Well, obviously there's not a lot on that, but I can tell you just by way of analogy, in other contexts in determining, you know, grounds for indigency, the laws have, you know, found lesser emergency matters to be deemed to be calculated as to be not included in the calculation. So, for example, there's another statutes, which actually there's footnotes in our notice of appeal that cite to these things, but there are exceptions made for an allowance for $2,500 in a bank account that would not render someone not indigent. There's a $15,000 allowance for automobiles. And retirement funds, I don't believe are supposed to be used for in those calculations as well. So, you know, that's the authority for there. As far as something specifically for the emergency legislation, I mean, you know, no, it's just I think the recognition for that is that people are going to be bearing some additional expenses in staying at home, in dealing with childcare, in dealing with food, in dealing with, you know, preparatory things like emergency equipment or you know, masks and cleaning utensils and all kinds of things that just would come up that we can't always predict. And I don't think that that would really fall under a filing fee. And just the general notion under our Constitution here in Massachusetts is that someone's supposed to be able to bring an appeal and not be obligated to pay for that justice and that due process.
And just so I'm clear, understanding the argument you were making earlier, even if I were to accept your argument that the additional bonus money that's listed in the most recent, and that's the May 15th, 2020 affidavit, were eliminated, your client would still be $100 in the black, so to speak, on the calculation between money in and money out. Is that correct?
Yes, Your Honor.
Okay. I also know that although this hearing was set up with respect to the waiver of entry fee, there were a couple of other motions that were filed in the meantime, and I don't expect anyone to feel they must argue either one of those, but if you'd like to be heard with respect to them, I'm happy to give you an opportunity to do that in your remaining time. Mr. Wasser, is there anything else you'd like me to hear with respect to any of those motions?
Sure, I'll address them briefly, Your Honor. As far as their motion for use and occupancy, I just think that's ridiculous. A little shocked by it. They're asking for basically a use and occupancy bond, or AKA an appeal bond. I just don't think that we should be seeking. There's no logic and sense to be seeking an appeal bond in the context of an appeal on whether or not an appeal bond should apply. So, they're looking for some kind of a bond or security during the pendency of whether or not a bond is even appropriate. To me, that's just patently ridiculous, and there's nothing in the statute in this procedural process to indicate that anything like that would have its place here. So it seems just highly inappropriate in every context. Their motion concerning the caption, it's not a critical issue on the surface. However, there is still a lot of uncertainty of who are the parties to this lawsuit. As it stands, there's no formal judgment, that's ever been made to withdraw Bayview loan from being the plaintiff. But what did happen was a post-judgment, an attempt was made to change the caption, and the court did allow it. And so there was a caption change that put Bank of New York Mellon in there as the plaintiff. But I think that, that's not really the issue primarily before this court today. And if we are going to be changing the caption, it should be changed to something that appropriately reflects who the actual parties are. And so substantively, when you look at the parties, clearly it's Bayview. They brought the lawsuit. When it came to doing counterclaims, we could only limit our claims to claims that would be appropriate against a servicer, nothing against a mortgage holder. Due process, discovery, everything was against Bayview. So to suddenly sneak Bank of New York Mellon in at the end, I just think it tells the story and kind of illuminates it for the reviewing courts as well as to what's going on by, at a minimum, leaving Bayview in the caption. Thank you, Your Honor.
Thank you. Anything further? I know that Mr. Smith had a motion to enlarge time.
Oh, yes. Thank you. I'm sorry. I forgot about that. So, Your Honor, if you look at the extension times when we calculate for the COVID-19 emergency legislation or orders by the court, by the Supreme Judicial Court, I believe that brings us to June 15th. So really asking for basically in a 60-day extension. This is pretty much commonplace in this context in appeals generally, but I have a lot of circumstances which, I've only listed a handful of them. I can tell you, I wasn't that comfortable putting too many things in writing. I try not to disclose too much if I can help it when they're personal in nature. In my writings, it's certainly, but, oral argument, I'm happy to expound upon the idea that when I mentioned about, school starting up and I have a new student going into college, parenthetically, my son is on the autism spectrum. And it's actually a big deal for us that he's, come so far. I mean, I can tell you, when we started, when my son was born, he didn't make eye contact.
Mr. Wasser, just let me remind you of the fact that we are live streaming this information. And so I just mentioned that to you as you decide how much disclosure you'd like to make on this argument.
Yeah,
on that point.
I appreciate that, Your Honor. These are just things that I didn't say in my motion that I think, it's enough to be said that it's not just a normal, ordinary student going to college. It's just that just compounds it, that we have additional considerations based on a disability. But it's being the season of, summertime, and we're coming off COVID. It's not like everything just ends because the emergency orders are brought us to June 15th. There's a lot of recovering that's going on. People need to get doctor's appointments, and pets need their appointments, and cars that needed recall notice. I mean, the list goes on. And it's for me. I also have multiple other appellate briefs that I'm getting in on other cases, and so the reason I asked for, I believe it was September 15th as the deadline. Part of that is to give some cushion. We have summertime coming. If I am going to bring in other help, like if I try to contract something out to say, a paralegal or something, then all of a sudden I'm going to start hearing issues from them in their schedule, which I don't even have now. So some of it is, for my own personal needs. Some of it is just being provident. We don't even know what's going to be happening, with the pandemic issue. Right now, everybody's, there's a lot of pressure to go back to normal when in reality it's still out there, and there are already reports coming in of some resurgences. So, for my own personal interest, I have to go on summer vacation starting in mid-August. It's in my own best interest to get this work done before then, so that I can kind of relax on my vacation and not worry about an appellate brief. But that being said, I put in September 15th because it's post-school starting. It gives me a little extra buffer, and hopefully, handles any uncertainties or unknowns that might arise going forward in the future. And, as I said, I don't think we're asking for anything extraordinary or out of the ordinary. As I mentioned in my brief, my brother was concerned about the summer months, but, this is not something that's going to be decided even on a normal schedule. It's not going to be decided before the summer anyway, so I think that was sort of a non-issue. Thank you, Your Honor.
Thank you very much. Anything further, Attorney Wasser?
No, Your Honor.
Okay, thanks. Attorney LaBianca. Your sound is off.
Yeah, is that better?
Yes, thank you.
So may it please the court, in response first to the motion to waive the fee, we obviously don't have access to all the impounded materials. So that's not really a matter we can address, other than to say that Mr. Wasser pointed out his client has a positive cash flow of $100 absent any emergency funding, which suggests that he isn't actually indigent. It also, this whole scenario raises an interesting question that that this whole appeal is regarding whether or not he can pay the underlying appeal bond, and now he's moved to waive the appellate fees. And if he's deemed not indigent for the purposes of paying the appellate fees, does that resolve the matter regarding whether or not he's indigent for purposes of paying the appeal bond? But again, this isn't a topic we can really address in too much detail, since we don't have access to all the facts. And we simply point out that Judge Barrett requested multiple documents, wrote a thoughtful decision denying the appeal bond waiver request, and it was then reviewed by the Southern District Appellate Division and affirmed the denial of the waiver. Regarding the motion for use in the so-called motion for use in occupancy, that's a mischaracterization of what Bank of New York Mellon has requested. We request simply that if the appeal proceeds, that the money that is collected for use in occupancy by Mr. Smith for the subject property be paid into court. We're not asking that it be given over to Bank of New York Mellon. We're asking simply that it be held by the court pending resolution of the appeal. If this matter is in fact, if the lower court decision is affirmed, then the money at that point could be released to Bank of New York Mellon, but we're not asking for an order for use in occupancy. We're simply asking that the money be paid into court, because otherwise it constitutes a windfall for Mr. Smith, who by protracting the litigation through the summer months manages to collect valuable rent on a property in Nantucket pending the resolution of the litigation. The motion regarding the caption, amendment of the caption, Mr. Smith's motion our opposition to Bank of New York Mellon's motion grossly mischaracterizes the procedural background of the case. The motion to amend the caption has attached to it Justice Barrett's order allowing the caption change. It sets out in there, the order, which is a handwritten order on the motion that was made in the trial court. It sets forth in detail the procedural history of the district court case, and it sets forward exactly what happened. I don't think there's really much that we have to add to that at this point. Other than to say there was no question at any point about who was the plaintiff bringing the case, and the summary judgment arguments were made with the caption titled Bank of New York Mellon as trustee. So we also, I'm happy to answer any questions the court might have about that, but I think otherwise it's laid out. Also, at our basic argument is that that's not at issue here. This is quite simply a motion, an appeal of the denial of the appeal bond waiver. The court's review is limited statutorily to that issue. We cite the appropriate case law in our brief regarding that matter, which is Erickson v. Summers, 446 Mass 1015, 2006. And we believe that it's not appropriate for that for Mr. Wasser or Mr. Smith to challenge the lower court's rulings on anything other than the denial of the appeal bond waiver request. Finally, regarding the motion to enlarge time, we do agree that it's standard practice for there to be an enlargement of time upon request. However, this is not a complicated appeal. This is simply a review of the lower court's decision regarding the appeal bond waiver request. This shouldn't take a lot of briefing, and given the SJC's COVID order, there's already a sizable extension, which should allow Mr. Smith adequate time to brief the issue. I'm happy to answer any questions the court has, but otherwise I don't think I have much more to add at this time.
Thank you. I appreciate very much the materials that each of you has provided on behalf of your clients to the court. I appreciate your time for today's hearing. I'm very grateful to Madam Clerk for her participation, assistance, and technical expertise. The case is submitted, and I will take that under advisement. Thank you all very much.
Thank you, Madam Justice. Thank you, Madam Clerk.